Lashley, 2014 CR 82. The state of Ohio is represented by Assistant Attorney Generals Paul Scarcella and Brian Deckert. The defendant is in court. He is in street clothes. He is represented by Attorney David Grant and Patricia Snyder. The defendant previously has pled guilty. There is a stipulated sentence as part of that plea agreement that there was a joint recommendation of life in prison with parole eligibility after 30 full years as to each count to be served consecutively. That is a stipulated sentence under 2953.08. Is that correct,
Yes,
Ms.
Your Honor.
Snyder?
Yes, sir.
And is that correct, Mr. Scarcella?
Yes, Your Honor.
No pre-sentence investigation report was ordered. However, by agreement of the state and the defense requested that this be set for a sentencing hearing so that they could introduce certain evidence or reports into the court record. At this time, Mr. Grant and Ms. Snyder, did you have any witnesses you wanted to call or any documents you wanted to offer?
Yes, Your Honor, we have several documents. We have an allocution and one witness we'd like to speak.
Okay. And I will let you call whatever witness you want to call.
We're just going to ask him to let the court
go right
know
ahead.
about the course of conduct. So just
I'll say that Marcus Lashley has been an inmate in the Ashtabula County Jail since, I believe, February of 2014. Since that time, he's had 10 disciplinary violations. He had disciplinary actions taken against him in which he was placed in lockup or some sort of restriction for all those 10 violations. When I went through and reviewed his disciplinary record, he had his last disciplinary action taken against him in April of 2015. He's had 282 days in the Ashtabula County Jail without any disciplinary action taken against him.
Okay, thank you. Was there anything else you wanted to ask him?
just what his behavior is on the pod.
Did you say on the pod? Attorney?
Yes.
I can't hear.
I don't deal daily with the inmates as the correction officers do, but I can say that I haven't had any reports of any difficulty or any problems with Mr. Lashley. In fact, I did have a positive report from him recently in which there was a fight up in his housing unit or his pod, and Marcus Lashley broke up that fight for the officers.
Okay. Mr. Scarcella or Mr. Deckard, any questions for the lieutenant?
No, Your Honor.
Anything further on behalf of the defense?
Yes, Your Honor, thank you. Please support. My first exposure with Marcus was back in March of last year. I know Patch was in February.
March of 14?
I'm sorry, 2014, that's correct. And I can say, Judge, the first time I ever went to see Marcus, I mean, literally he was bouncing off the walls. He was irritable, he was tense, he was paranoid. Virtually you couldn't have any sort of real communication with him. We requested of Judge Mackey, your predecessor, that he be seen by a psychiatrist for determination of whether he needed to be medicated. And Dr. Keaton came out and spoke with him and determined that he did need to be medicated. And through the efforts of Dr. Keaton, Dr. Karpowicz, who I'll mention in a minute, and Dr. Weintraub, he has been medicated. And since the time he was medicated, his persona has changed 100%. He's now been easy to deal with. He's been cooperative. He's been amiable. We've just simply seen a total change in his whole ability to relate to us and relate to others and ability to conduct himself. Through discussions with Marcus's family, through records we've reviewed in terms of his history and background, we've learned a number of things about Marcus. First of all, it's pretty clear from the records that we've reviewed and the interviews we've conducted, is that Marcus unfortunately had a very dysfunctional upbringing. His parents both suffered from significant substance abuse issues. In fact, at the time Marcus was arrested, his mother was incarcerated for substance abuse issues. His father, in addition to the substance abuse issues, had issues with mental health, and certainly that was an issue as well. To exacerbate that problem, Marcus had cognitive limitations growing up. The records clearly relate that early on, he had speech difficulties in terms of expressing himself and difficulties in comprehending other people's language towards him and what they were basically trying to tell him. He largely grew up unsupervised, Your Honor. He grew up on the streets because his parents were dealing, and not that they didn't say love him, but because they were dealing with their own issues. They weren't really able to devote the type of attention to Marcus that he should have had, and to help him deal with some of these cognitive issues that he's developed over the years. Marcus started using drugs at a very early age. We've documented that at age as early as 13, 14 years old, he was already consistently using various drugs. I believe to some extent that was
Excuse me, slow down just a second. 13 or 14, you started using what?
number of different drugs, which I suspect was in many ways stuff he'd seen his parents doing, as well as perhaps his own attempt to self-medicate, deal with some of his own issues. Dr. Weinkoop, a neuropsychologist, evaluated Marcus and indicates that a significant chance that he has what's called an auditory processing disorder. And that means he has issues with verbal comprehension, reasoning, and verbal expression. Meaning that essentially that he has difficulty communicating with others, as well as understanding what other people are saying to him at various points in time. During the period of 2011 to 2013, Marcus was in prison. And during the period of time he was in prison, he was on various psychiatric medications, mood stabilizers and antipsychotic medications. And it certainly appeared from the records that he was responding well to those medications. When he got out in 2013, he stopped taking those medications. And it's our belief because largely he didn't have access to them and wasn't being supervised and required to take them at that point in time, even though theoretically he was on post-release control at the time. And when he stopped taking those medications, I mean, again, he reverted back to the use of drugs as a form of self-medication. He was taking considerable, he was smoking marijuana, I don't know, I read in one of the reports he was smoking as many as 40 blunts a day. Literally in a daze most of the time through drug usage. And again, I think it was largely self-medication because he wasn't taking the mood stabilizers that have been helping him while he was in jail, and probably mood stabilizers he should have been on for a long time. And I believe that this whole issue with the drugs and with the failure to take his medications contributed in large part to his conduct in this particular case when he came out to Ashtabula. And certainly, Your Honor, we can't in any way condone or justify anything that happened that day, and we're not going to try to. But I would indicate, Your Honor, that Marcus didn't go to the clone home on that particular day with the intent of taking someone's life. Unfortunately, they went into the house, they were armed, and obviously good things don't happen when you walk into someone else's house with a gun. But I don't think they anticipated that the Colognes would react aggressively, which I think they had every right to do. And we're not criticizing or in any way what they did in that house. But based on the fact of how they reacted, Marcus simply lost it and did what he did. And again, we're not trying to justify or excuse it, but simply indicate that wasn't his intent walking in the door to take anybody's life. And I do believe, Your Honor, that Marcus has expressed remorse since this happened. In fact, his co-defendant made a statement that immediately after it happened, they got back to the car, Marcus threw up. I mean, literally, I think he was as shocked by what he had done and stunned by what he had done as anybody else. Your Honor, we hope that at some point in time, Marcus we hope he can remain stabilized on medication because, again, as we've indicated, he's very much a different person when medicated. We would like to ask the court to include as court exhibits or defense exhibits a report from Dr. Weinkoop, the neuropsychologist, who suggests that he has this auditory processing disorder, and also a report from Dr. James John Karpowicz, who again has indicated and detailed in great detail what Marcus's issues are from a psychological standpoint, with the hope that in the institution, he can get the sort of medications and the sort of therapies that might help him continue to be mood stabilized and certainly the type of person that we now have sitting at this table. So I'd like to introduce these perhaps as defense exhibits A and B if I can.
Any objection, Mr. Scarcella?
No, Your Honor.
Okay, well, Mr. Grant, why don't you sign this before?
We're just proposing, actually, this is emailed over, Judge, I'm sorry.
This isn't something different, huh? You're gonna give us an agreed entry,
This is what we're asking to be the entry.
okay?
I'm not sure what that is.
It's for his medical record.
I'm not sure what that is.
Do you, I can't hear the last sentence you said, Judge, if you wanted on the record. You
The
said
entry
that's,
deals with medical records.
This has nothing to do with that decision.
Okay, then we'll put on an entry for the cost.
Your Honor, I guess in closing, I'd simply ask the court, we have a agreed recommended sentence. We ask the court consider imposing that particular sentence.
Okay, and that is an agreed sentence or stipulated sentence under 2953.08.
That's correct, Your Honor.
And Mr. Scarcella, that's your agreement?
Yes, Your Honor.
Okay. Anything else on behalf, Mr. Grant, anything else you would like to say?
Yeah, Judge, Pat brings up another point that it's important for the court to know. Dr. Weinkoop believed that there was an auditory processing disorder here. It would require, to confirm that, would require some additional testing. We simply couldn't do in the context of him being in a county jail. We contacted people all over the state to be able to complete the testing that would have been necessary. And we couldn't find anybody who'd be willing to go to a county jail to do that testing. So that's the only reason that there wasn't a confirmation of that particular disorder. We're still hoping perhaps it can be done down the road, but within the context of this case, that testing couldn't be done.
Okay, thank you.
Thank you.
Nothing else, Ms. Snyder?
Judge, only along those lines, the Sheriff's Department did indicate a willingness to transport Mr. Lashley to an audiologist if we were able to locate one. I personally contacted every audiologist that was listed in Ohio, and none of them was willing to either come here or allow him to be taken to their facility. So that was why the testing was never accomplished.
Okay. Mr. Lashley, I am required to ask you, is there anything you would like to say?
Yes, sir. Do I stand?
You can if you would like, yes, sir.
I was going to write something, but I just wanted to say to the Honorable Judge Harris, I'd like to thank you for being patient with me and to tell you that I am grateful to have a judge as smart and as righteous and as fair as you are. For almost 2 years, I sat still. I had a lot of time to think, to cry, also like to suffer, and to change from the horrible person I was to who I am now, and to pray about the sad sins I committed. And I know there's nothing I can do to bring back their family, but to say I'm really sorry, and what my life excluded from society, I shall pay. But I do want to go on and say that I'm not a bad person. I just made bad decisions. And I'm not a cold-hearted killer. I was just as frightened as they were. And I'm not asking for sympathy. I'm just hoping for peace and forgiveness. And even though the family may never forgive me, it's okay because I forgive them for not forgiving me. And last, on a positive note, I'd like to thank my lawyers for fighting for me. I'd like to thank my doctors for listening to me. Thank the COs for helping me. And thank all my family and my loved ones for supporting me and not giving up on me. And I'm sorry. And to my kids and Jesus Christ, I shall live through from this day on. Thank you. That's all I want to say.
Mr. Lashley, just to make sure we're clear, you understand what sentence I'm required to impose upon you today, correct?
Yes.
And what sentence do I have to impose upon you?
60 years to life, Your Honor.
Correct. Good. Anything else, Mr. Grant, on behalf of the defense?
No, Your Honor, thank you.
Mr. Scarsella?
Nothing from the state, Your Honor. We do have a representative from the family who would like to make a statement.
Up, please.
My name is Jennifer Avalon. Lydia Avalez was my sister-in-law, and Alexis Smoke was my nephew. I'm also thanking the Lord that my other nephew was dramatically traumatized. Benny is still here with us today. I am writing you this letter to tell you how the murders of Marcus Slavery and Taquan Mather's actions and decisions impacted my life on January 27, 2014. It has almost been 2 long years. On January 27, 2014, Marcus and Taquan made the intentional decisions to go into Lydia's home by kicking in her door, only to find out that they supposedly had the wrong house. Marcus and Taquan then didn't decide to turn around out of Lydia's home and run. They continued to look in her eyes and murder her and her kids. To be that selfish and take away someone's life can only mean you don't care. My wife, Erica Avalez, got the call on January 27th. I witnessed her dropping to her knees and screaming, to only find out that my nephew was shot and killed instantly. Lydia was being flown to Cleveland Hospital, and Benny was on his way in the ambulance. I was in shock and confused of what happened and what's going on. I sat there and questioned everything. Who would do this, and why would they do this? We immediately left where we lived and headed to Cleveland. Within minutes, they called my wife and told her that Lydia had passed. We had to pull over and catch our breath. All I could do was pray that Benny pulled through. We spent days in the Cleveland hospital until he came through. Almost 2 years now, and I had to leave my wife duties to become a full-time caretaker. Erica worked herself into a coma because of her sister's death, and I thought I was going to lose her too. My wife, she pulled through it. The doctor gave her 1% chance of living. I didn't even want to think of having to tell her my mother-in-law, that she lost another daughter. Not too long after that, her mother passed, without knowing that you guys will have God justice. She had to watch her mother die slowly. Erica had to watch her mother die slowly too, and ask for Lydia for months, and her grandkids. She died being heartbroken. My wife Erica got a lot more unstable now, having lost 3 family members in a matter of a year and a couple months. I have to stay strong because she needed me more than ever. I had watched Erica fall apart for 2 years. This family has fell apart. Erica is not the woman that she was. This family isn't the family it was. The mother, sorry, Mr. Harris, I could keep going on. I probably could write a book, but what it has done to my family. But I'm just asking you to give us justice today and give him what he deserves.
Thank you. Mr. Scarsella, anything else from the state or from the victim's representative?
No, Your Honor, thank you.
Okay. The court finds that there is no good and sufficient reason why the sentence should not now be pronounced. The court is required to consider the purposes and principles of the sentencing statutes. The overriding purpose is to punish offenders and to protect the public from future crimes. The court's looked at the recidivism factors, with this defendant having previously been incarcerated. Recidivism would be considered likely. The court's looked at the seriousness factors. They don't get more serious than 2 aggravated murders. The court finds that consecutive sentences are necessary to protect the public from future crimes and to punish the offender, and that consecutive sentences are not disproportionate to the seriousness of the offender's conduct and to the danger the defendant poses to the public. Also, pursuant to the plea agreement, this is a stipulated sentence under 2953.08. So, pursuant to that plea agreement and pursuant to state law, on count 1, the defendant will be sentenced to a term of 30 years to life in prison. On count 3, which is also aggravated murder, both of these are under 2903.01A. He additionally is sentenced to a term of 30 years to life, and that those 2 sentences shall be served consecutively to each other. So, Mr. Lashley, as you correctly stated, we're getting 60 years to life. Mr. Scarsella, it is my understanding I have no alternative but to give him jail time credit for the time that he's been in since he was originally arrested.
That's correct, Your Honor.
And we will calculate it. Do you have a day's calculation?
I do not have a number of days calculation, but I can have that for you shortly from the
Okay.
sheriff's office.
There will be no disagreement on that.
No, Your Honor.
He was arrested on what day?
February 11th, Your Honor.
Does that sound correct?
We have no objection to that date, Your Honor.
Okay, so he'll get credit back to February 11 of 2014.
Correct.
And I have to give him that under state law. He is not eligible to earn any days of to earn credit to reduce his prison sentence because these are mandatory prison sentences. He is not eligible for probation. We will sign the agreed entry on the court costs, the deferral of the collection. There was no request or order for restitution, but the victims are entitled to the victims of crime procedures. Correct, Mr. Scarsella?
That's correct, Your Honor.
Now, under state law as it presently exists, after you have completed serving the 60 years, I don't know what other sentences may be imposed upon you in other courts. In the event, 60 years from now, the parole board and the Department of Rehabilitation and Corrections, and I'm just assuming the law stays the same, but generally the law changes. If they would ever let you out, and you would be well into your 80s, correct?
Yeah, that's right.
You would have to be under parole supervision under current law for a minimum of 5 years. But I have no control over that. That's between you and the state, and whatever the General Assembly does in between now and then. I am required to advise you. First of all, any bond that was set that was never posted is previously canceled, so you will not be released. I am required to advise you that you have the right to appeal this court's conviction and sentence. You have 30 days from today's date to file your appeal with the 11th District Court of Appeals. You have a right to a free court-appointed lawyer to represent you in the Court of Appeals, and you have a right to a free transcript of all court proceedings that could be prepared for you at no cost. Do you understand those rights?
Yes, sir.
Okay, however, was there anything else that needed to be brought to the court's attention? I will say that I did receive victim impact statements, and I read every word of every one of those statements. Anything further, Mr. Scarcella, on behalf of the state?
No, Your Honor.
Anything further, Mr. Grant, on behalf of the defendant?
No, Your Honor.
Okay, we have a lot of people in the courtroom. I'm going to ask the Sheriff's Department to at least leave one person behind and remove Mr. Lashley from the courtroom. Everybody is required to remain seated in their place and not move or reach out towards Mr. Lashley. I'm assuming he's being taken to another courtroom.
Fucking killer, you son of a bitch! You stupid son of a bitch! You took my fucking brother and my mom! No! Don't touch Don't fucking touch me.